Welcome to part two, chapter six, The Legal and Ethical Environment of Business by Terrence Lau and Lisa Johnson. This is Kent Gregory, and we will be discussing contracts or continuing our discussion of contracts. So, for a contract to be valid, uh, the subject matter of the contract has to be for a legal purpose. Uh, and the legality requirement is a reflection of public policy and demonstrates that a willing seller and a willing buyer are simply just not enough to form a contract. So it has to have that legal purpose. Um, the contracts in restraint of trade, for example, are generally illegal except for non-compete agreements. However, in a lot of states, the non-compete agreements can't be enforced if it prevents someone from working. So non-competes are a very tricky concept, and we'll talk about those in class. Capacity. So we referred to this a little bit before. So the parties of the contract have to have the capacity to enter into it. So adults of sound mind have capacity. A minor who enters into a contract uh, with a party who has capacity may void the contract, but the other party may not. So the bottom line is a contract with a minor is voidable by the minor or his or her representatives. And capacity issues sometimes arise when people are intoxicated. So a little bit about UCC contracts. Where contracts under UCC are usually governed by or are governed by Article 2 of the UCC, and it defines goods as things that are movable, but not money or securities. And another point of worth or point worth mentioning is contracts between merchants do not always contain offers that include definite terms, and acceptances are not always mirror images. So as a result, merchants will often use boilerplate language, and in the boilerplate language, it's just standard legal language used in contracts or other legal. Um, the UCC embodies the statute of frauds, uh, and it requires certain types of contracts to be in writing to be enforceable. And it's got to be written in writing and signed by the defendant or potential defendant for goods priced at $500. Um, and other types of contracts that the statute of frauds require to be in writing are contracts for real interest in real property, debts, marriage, and contracts that can't be performed within 1 year. So, key takeaway, common law and the UCC are different sources of contract law. Common law is the appropriate type of law for service contracts and contracts that do not fall under the UCC, like real estate contracts. Um, Parties have got to have capacity, as we mentioned. And finally, the UCC relaxes formation requirements by allowing the use of gap fillers for undefined or conflicting terms, and by allowing a contract to be formed by any manner that shows agreement to contract. So again, the UCC is looser than common law. Some contract term or some words about contract terms. Contract is an enforceable promise, and when the promise is fulfilled, the contract terms have been satisfied, and then the parties are discharged from the contract because they've fulfilled their legal duties. Performance. So undertaking the legal duties imposed by the terms of the contract. And then complete performance. This is the full and perfect performance of all the promises, obligations, and duties contained in the contract. Contract breach. This is when a party fails to perform under the terms of the contract without, this is key, a legally justifiable reason. In a service contract, the standard of performance is substantial performance. So it's a little bit different simply because it's a service contract. So substantial performance versus strict performance. Substantial performance is the standard for service contracts. It means that the performing party acted in good faith and conveyed enough benefit of the contract to the other party. Strict performance means a standard of performance in a contract that requires perfect performance. Personal satisfaction. This is another key issue. So performance to the standard of personal satisfaction means that the performance is scrutinized subjectively, either by a party to the contract or by a third party beneficiary specified in the contract. A reasonable person's standard, an objective standard based on reasonableness against which actions are measured to determine sufficiency. And when promises in a contract have been fulfilled based on the appropriate standard, then the parties are discharged. And then if there's a material breach, the injured party can claim for damages. So some defenses to contract breaches, and we'll not go through all of these that are listed, but some of these could be formation problems, lack of capacity, impossibility, duress, unconscionability, undue influence, a mistake, misrepresentation, fraud, commercial impracticability, and frustration of purpose. Equitable remedy. Formation problems in common law contracts relate to whether the offer, acceptance, and consideration were valid. When all of the elements of the contract are not present, the court will enforce the promise through an equitable remedy. So an equitable remedy is a remedy imposed by the court to prevent injustice, which allows the court to enforce the terms of the contract, even though technically speaking, there was no contract to begin with because the elements weren't there. And some types of equitable remedy, and this will wrap up part 2, quasi-contract. This is where this is a remedy that can be imposed on the parties to avoid unjust enrichment to one party at the expense of the other. So unjust enrichment is a benefit that's conferred or expected to be conferred unjustly. And then there's the concept of quantum meruit, the name for damages awarded in quasi-contract cases, which means as much as is deserved. And then promissory estoppel, the type of equitable remedy that may be imposed on parties to avoid injustice when one party detrimentally relied on another party's promise. So that brings us to the end of part 2 of chapter 6.